How do you sort out the so-called jargon from real-world practices that work? Do the members of your organization find some business or technology advice utterly confusing? Welcome to Real Talk with Sam Holcman. In this program, we set the record straight, and in terms that business people and technology people can understand. Now, here is your host, Sam Holcman.
Welcome to this edition of Real Talk. I'm Sam Holcman. Thanks for joining me. And the topic for this particular broadcast is just sort of an informational broadcast. And that has to do with the United States court system and artificial intelligence and all the things pending in that particular area that may be of an interest or concern to all of us. Because as we all know, if we start betting in that particular direction, AI direction, and there's some legal ramifications that are coming up, it may affect us, and from a standpoint of product development, et cetera, et cetera. Well, there's four areas that are being explored right now that we should be at least concerned with. Maybe that's too strong of a term. How about informed about? One is defamation. Another one is copyright. Another one is privacy. And the fourth category is responsibilities. And each one of these, as we speak here in this particular episode, there are lawsuits in the courts on each one of these. So this is not some speculation of potential liability issues that we all need to consider, but these are actually going through the courts right now, and there's no one that can predict where this is going. So please don't use AI to try to predict where these are going. Ha, 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 ha. Well, let's talk about one of them, and we'll go relatively quickly on these, and that's defamation. And what is that? That is essentially something that is being said that is just blatantly false and actually impugns the reputation of an individual or a company. Now, what is going on here is that some of the legal activities go back to essentially a shield that was in the telecommunications, the communications world, called Section 230. And it's been around for a while, and the courts have been talking about how this came from the telephone companies, the POTS telephone, plain old telephone systems, in other words, wire-to-wire connections, through cellular, through providers, through search engines, and now through HI. But basically, the question is, you're saying, or whatever it is saying something that is, defamation or to the reputation of the individual, or, as I said, blatantly false. And the question is whether that immunity applies to generative AI systems. I know some people call it hallucinations. Well, I call them mistakes. And sometimes those mistakes are really, really an issue, well beyond, we'll just laugh it off. So there's a couple of things that, have brought this on. One is a lawsuit in the courts in Georgia, and that's involving OpenAI. And basically, that is an area where this particular individual has been falsely accused of embezzling funds from a nonprofit group. And basically, the attorneys for this individual said all of this is just totally made up, 100%, just absolutely no relationship at all to this individual. And of course, the reaction by the AI company is, by its very nature, artificial intelligence generates content based on probabilities of predicting the next few words. And it's not always factual. Okay, when is it and when is it not factual? How does somebody looking at this know that this particular statement is actually false? And what the AI company is saying, OpenAI, is saying that if there's a universal consensus that anything that AI puts out there should be fact-checked. Well, how do you fact-check something that is false? And what do you use as the fact-checking mechanism if AI is generating the facts, which are actually wrong? I know it sounds circular, but think about it. This is kind of wackadoodle right now as it goes on there. So that's defamation, and it is active. And it's something that we really need to be concerned about. The one that hits me the most, and I've talked about this in other broadcasts, is copyright infringements, flat out. These engines are being trained on information that is proprietary. It is copyrighted. And copyright is just that. I, as the copyright owner, have the right for that particular element, whether it's a book, a movie, a picture, or whatever it is. And until I say that somebody can copy it, it can't be copied. And this one is really gotten the wrangles of a lot of folks. And as we have this broadcast right now, we all know the writer's strike in Hollywood. This is one of the main issues there. And it's going to get more complicated. And there's 3 class action lawsuits going on. These are big, 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 big things. And so if you and I are using these engines to come up with something, we are contributing or possibly liable for information that we're using that is copyrighted by somebody else, and we may have to actually, pay money and or even worse, have penalties, for the illegal use of this information. So it goes not only for the training of these AI engines on copyrighted information, which has not been compensated, but also the use of that, as it moves forward. And a very famous organization, Getty Images, is also suing an image generator for, as they call it, scraping millions of images from their archives without permission. This is, to me, blatant theft. Yes, I'm calling it as I see it, blatant theft. Third category, responsibility. In other words, who is responsible? Well, it turns out that this lawsuit isn't, and you need to pay attention to this one, not lawsuit against the AI company, but the organization that used AI. In this case, it was an insurance company. And again, these are only examples of some of the lawsuits that are out there. Cigna Corporation has denied an incredible number of claims that were pre-approved by human beings. And when they actually came in, they were rejected. And the question is, well, Cigna used this information of the AI engine to reject these claims, even though they were essentially pre-approved. And so the company, Cigna, who used the engine, is now essentially, the courts are looking at this, responsible for denying these claims for an incredible number of people. How would you feel, by the way? You come in there, something is done, a procedure of some kind. It doesn't matter if it's medical or other things that are out there. You're making the understanding you have a pre-approval for something, and then it's denied. Who's responsible for that as we move forward? And the last item, category number 4, is privacy. I think we all know what that means. In other words, where is this line between accessible information and things that are personal and violate federal and state privacy laws? None of this has been tested very well. And again, this is the 4th category. What the reaction of these AI companies is one divided by making sense. What do I mean by that? The companies now have, they tell us, the ability for us to opt out of having our personal information used for training. Oh, no. It should be, we should opt in. And this is what's being tested. Wait a minute. We have to opt out of our private information not being used? No, no, no. It should be the people that want to use it. You need to give us permission, and that's opting in. Lots of things going on there. A little bit longer broadcast than I usually have. Hope this adds to your knowledge base and just to get us to think a little bit about the things that are going on. Just an awareness as to the changes going on in technology and the use of technology, and more importantly, the use of data or information out there. We all know that that's really the fuel in the information age. Data is the fuel. Who owns that fuel is the question. Until next time, thanks for listening.
Thank you for tuning in to Real Talk. Be sure to join your host, Sam Holcman, again for another edition of our program. We'll have more real topics of discussion then.